Namaste. So, in the last session, we discussed on the concept of mediation, and we have already looked up after various definitions of the mediation, the statements of on the mediation, and some statutory definitions of mediation as well. And from the basis of the definitions which we laid down, we are able to draw most of the features of mediations, and some of them are like it's a non-binding process. We already discussed about non-binding process, a voluntary process, but once again let us highlight or elaborate once again on the features of mediations, whatever we have discussed while discussing the concept. So on the same basis, so these features of mediation are been drawn, and let us discuss it once by one. So mediation is a voluntary process. As we call it as a voluntary process because it allows the parties in a dispute to retain the control over the settlement of disputes. Because the role of mediator is only to assist, only to facilitate the mediation, whereas the whole mediation process is dependent on the parties and only on the parties themselves. And that is why the whole control of mediation process is on the parties, and that is why we call it as an voluntary process. And even if a court or a contract requires mediation, the decision to settle and the specific terms of settlements are ultimately in the hands of the parties involved. See, there are various statutes, including Section 89 of CPC, which mandates the court or a contract, if there is any contract between the parties, which makes a reference to a mediation, like the court directs the parties to go for mediation and try to settle out the matter, even in case of Commercial Courts Act as well. And even we have talked about this earlier as well, like Section 12A, which mandates the parties to go for a mediation. But with respect to the process of mediation, the control of the mediation and the settlement of dispute will lie within the hand of the parties itself, because the party themselves has to draw the terms of settlement. They have to discuss among themselves, negotiate among themselves, and reach to an settlement lies in the hands of the parties, and that is why we call it a voluntary process of resolution of dispute. When compared to other mechanisms of dispute resolution, like in court, in arbitration, conciliation, lok adalats, this process, this advantage we don't have in any other system of dispute resolution, and it only there in a mediation. And that is why a mediation is have such a great advantage, wherein the parties themselves resolve and create a win-win situation between the parties. At any point before the conclusion of a mediation, any party has the right to withdraw from the process of mediation without providing any reasons. And that is where the non-binding process, the voluntary process will come into picture. Like any time, if at all the parties feels like that the matter cannot be resolved without any reason, the party can step out from the mediation process. So coming on to the next feature of mediation, the mediation focus on the parties themselves. Like as I was already discussing, that the whole control will be in the parties themselves, and that is why the focus will also be on the parties themselves. Because when compared between the disputant parties and the mediator, a mediator has a very meager role to play in case of mediation process, because only he is assisting and facilitating the parties, whether he doesn't have any right to provide opinion, to provide any views during the mediation process. And the mediation process encourages active and direct participation of the parties in resolving their dispute. And the parties themselves have to reach to an amicable settlement. And that is where, when it's a voluntary process, when it is a party-centric process, then it's being a party-centric process, it would be obvious, it will be an informal as well. Although mediation is an informal and not bound by rules of evidence or a formal procedure, it is structured and formalized process with identifiable stages. See, mediation, we call mediation as an informal process because the process which we follow, or the parties being a party-centric process, the procedure may be informal in nature. But although it's still informal in nature, we can draw some stages of the mediation, like wherein at the first instance we welcome the parties, like the mediator and both the parties welcome each other for a mediation room. They sit together. Thereafter, the mediation process will start through the opening statement of a mediator, wherein he elaborates about the mediation process, about the advantageous nature of mediation, how mediation is an effective tool for resolution of dispute. He will elaborate all during the opening statement. And after that, it will go on to joint sessions and then private session, and then reach to settlement. And this is how the mediation process or a formal procedure can be drawn. These are just the stages of mediation, wherein it again dependent on the parties and the mediator to say the procedure. It may be skip one or two parts or one or two stages as well, like they may start up with the private session itself, or they may start up with the joint session and then go on to the private session, or if the needs arises, they may directly jump onto private session. So these types of situation may arise based on the situation of during the resolution of dispute. It's up to the call of a parties, or it's up to the call of a mediator. Like they can hold private session or a joint session and discuss and negotiate the disagreements and resolve the dispute. And that is why we call it as an informal process, and some stages we can draw. So that is why I have included the feature of mediation in a certain manner, wherein it is an informal, but even there are certain stages which we can follow while resolution of dispute. So mediation is essential and assisted negotiation process. Even when we were looking after the various definitions of the authorities, as well as the various statements on the mediations which have been made by various authors, so the mediation is an assisted negotiation process, whereas the assistance is been provided by the mediator to the parties to negotiate among themselves, to facilitate negotiation, wherein both the parties come together with the help of the mediator, they negotiate the dispute, they underline the concerns, they underline their interest, needs to resolve the dispute. The goal of a mediation is to find a mutually acceptable solution, and that satisfies the parties' needs, desires, interest in the legitimate and adequate manner. And this is where the mediator role plays, wherein the mediator will try and elaborate on the parties' needs, parties' desires, parties' interest, and help the parties to prioritize their interest, desires, needs, and based on that, the mediator will assist the parties to negotiate and reach to an amicable settlement. And that once the amicable settlement is reached, the parties will draw the terms of agreement and with the help of the mediator, and draws an agreement wherein both the parties sign and reach to an amicable settlement in a written format. Based on this analysis of a mediation process, we can even say that mediation provides an efficient, effective, and less expensive mechanism because it's an informal process, even it's a voluntary process, and that is where the efficiency of resolving dispute will increase. And that is why we call it an effective tool to resolve the dispute, and being less expensive because the mediator fees will be very meager, and wherein the role of mediator is only to assist the parties, and in that circumstances when compared to the other mechanisms like arbitration, litigation, in case of litigation we have to pay a huge amount of court fees, the advocate fees, we have to bear the cost of litigations, and when we compare all these things, so the mediation is less expensive when compared to the other modes of resolution of dispute. And that is why we call it an efficient. Why we call it an efficient? Because it is been carried out in a speedier manner. Effective is because if there is a successful mediation, both the parties will be on a win-win position, and that is why we call it an effective position. And the another important features that we all observe while resolution of dispute is with respect to the principles of natural justice, and those principles of natural justice are even required to adhere by the mediator as well, that he is required to remain impartial, independent, detached, and objective throughout the process of mediation. See, in these circumstances, if there is a slight, if the mediator is been slightly looking at some only on a one party, or if he is concentrating more on only on one party, the other party may feel bad, and the party may feel like the mediator is biased on the one party, and being it's a voluntary process, without any reason the other party will walk off. The mediation won't be any successful. So the mediator role is required to be very objective, very keen during the mediation process, and the mediator has to follow all the etiquettes and is required to take care each and every circumstances. Even the body language of a mediator plays a very vital role to maintain the impartiality, the independency, detached, and the objectivity. So the mediator assists the parties in resolving the dispute but does not impose a decision upon them as an adjudicator would. In case of arbitration, in case of litigation, in the courts, so the court makes the decision of the matter which is come forth before the court or before an arbitrator. But in case of mediation, the mediator doesn't have any right to impose any decision on the parties, because it's a party-centric process wherein the party themselves negotiate and come to an amicable settlement. That is why the mediator cannot make decisions, he cannot make opinions, he cannot provide views, he cannot provide suggestions. His role is mere a facilitative and evaluative, managing the interaction between the parties, promoting communication, managing conflicts, and motivating the parties to reach to an amicable settlement. His role is mere a facilitative, that if the party says yes, then and request the mediator to convey that yes to the other party, then the mediator shall convey yes to the other party. And even during at the time of communication, if at all the one party asks the mediator to convey same thing to the other party, only under that circumstances the mediator can convey such information to the other party, or else he may not. So the consent is must when a party is communicating one info, or when the mediator is communicating or transferring the information from one party to another party. The consent of such party who has provided the information is must. Along with that, a mediation, in order to undergo a mediation, the consent of both mutual party are must, because it's being a party-centric process, it's being a voluntary process. So the mutual consent of the parties is must. Either it may be a court annexed mediation centers, or say for example, even the legislations like the Consumer Protection Act even recognize that there has to be a consent of the parties in written form, which is required to be submitted to the president of a consumer commission before it has been referred to mediation. So the consent of the parties is must, and the same is been recognized by Supreme Court in case of Aktish Chandar versus Ramesh Chandar. This is a case of 2007, wherein the court says the mutual consent of the parties is required to refer a matter for mediation. Another important, very important concept or the feature of mediation is confidentiality. So the process is a private and not an open to the public. The statement made during the mediation cannot be disclosed in civil proceedings or elsewhere without the written consent of all parties involved. So that is where the crux of mediation lies. So mediation is a private mediation, or it cannot be public. The mediation cannot be in a public. So whatever that has been discussed in the mediation or during the mediation process, it will lie within the four walls of that room. Even if at all the mediator who has taken points during the process of mediation, that has also to be discarded once the mediation process comes to an end. And the confidential nature is such a way that even the various statutes and even the various case laws have also recognized the confidentiality of mediation, that whatever the discussion that has been taken place in the mediation room, that cannot be discussed elsewhere, or it cannot be used as evidence or record for settlement of any disputes before any litigations. And even the court says that in case the party has been settled or the case has been settled through mediation, when it is a court annexed mediation or when the court referred mediation process that has been taken place, only the settlement agreement will go to the court. That the settlement agreement which has been drawn by the parties with the help of mediator will go to the court, and the same will be further passed as a decree of the court. But whatever the discussion that has been taken place, those all will remain confidential. And the same has been recognized in various cases as well. So I have referred to the two cases. That is, one case is Motiram versus Ashok Kumar. This is a case of 2011, and Dayavati versus Yogesh Kumar Gosen. This is a case of 2017. Wherein in case of Motiram, wherein the mediator in his report mentioned the reason for unsuccessful mediation, the court observed that the confidentiality of a mediation process is necessary and the mediator should not include anything in the report without the consent of all the parties. In case the court has referred a mediation, if a court has referred a case for a mediation and the mediation is unsuccessful, in that circumstances only the mediator has to mention that the mediation is unsuccessful. He may not mention any reasons at all, and it's only to the extent that the mediation is not settled, only that extent the report has to be submitted by the mediator to the court, wherein the court will provide a date for a parties to appear and the case will proceed as it was proceeded as per the procedure of Civil Procedure Code, the courts. So that is where the confidentiality is. So even the mediator is restricted to provide whatever that has been discussed to the court in his report. If it's not settled, he has to only provide that it's not settled. And the same is also even recognized in case of Dayavati versus Yogesh Kumar Gosen, that this is a case with relation to section 138 of NI Act, that is check bounce cases, wherein The procedure to be followed upon settlement and legal implication of breach of mediation settlement is the subject matter of this judgment. That data given to the mediator cannot be used for any other purpose beside helping the mediator to reach an appropriate resolution. So here also the court says that whatever that has been discussed or whatever that has been given to mediator, that should not be used for any other purpose beside helping the mediator to reach to an appropriate resolution. Here, in a mediation process, it will be having more greater control on the process of mediation. As the mediation increases the control, the parties that statement which has been included in the PPT is bit it is bit error. There is a bit error in the PPT, like greater control, because it's a party centric. The parties will have more control over the procedure of mediation, and that is where, when the parties have the control and they are even free to choose the time, the location and the duration of proceedings for like where we should sit, what should be the location, what should be the time of the proceedings of the mediation, and these all are in the hands of the parties itself. And this is the greatest advantage. Another major advantage is that neither of the parties loses and the interest of both the parties are being conserved. So that is where the mediator only facilitates, and that is why he doesn't make any decision. And because he doesn't make any decision, the parties have a free mind to uphold their interest, what they have to lose, what they cannot lose. And it's a party, being a party centric, so the parties are as a greater control with respect to their interest, with respect to their losses. And that is why the mediation process, we call it it has a greater control in the hands of the parties itself. And the control in the hands of the parties will provide more advantages to each and everyone, which results that either party has advantage of terminating the mediation without giving any reasons. And these all things, like if at all he feels like this cannot be settled through mediation, then without any reason he can go out. So the whole control is in the party's hands. There is nothing in the hands of mediator, because it's being a party centric, it's up to the parties. And having greater control over the process of mediation, it is very advantageous to the parties themselves to reach to an amicable settlement, even under circumstances, because having a greater control, even the implementation will also be very easier, because in case of adjudication procedure, there is a lot of stages. If we have to file an executive petition. If a decree has been passed by the court, on such a decree we have to file an executive petitions to get implementation of such a decree. And that is not the case in case of mediation, because the party themselves agree to settle out the matter. At that instance itself they can settle out and just resolve the dispute. But in case of adjudication process in the courts, again the parties has to file an executive petition to resolve, to implement such decrees, even in case of arbitration as well. And that's the crux, and that's the greater advantage that we all have in case of mediation process. And even reduced cost, as I have already been discussed with respect to reduced cost, like generally the cost is greatly reduced in comparison with trying to settle the matter through courts. Traditional litigation is very expensive and the total cost is highly unpredictable, because we don't know when the matter is going to settle. The other party may file an appeal before. We have a lot of appeal procedures, and there are procedures which are involved in the courts are even high, costlier, and that is where the mediation process is less expensive in nature. Convenience, again it's very convenient for both the parties to hold the separate rooms for joint session. Either may they choose their own place Even their home may be the place to resolve the dispute. The mediator listens to everyone's views, talks to the parties privately and together, guiding them towards a settlement, wherein the mediator only, like, he will be a watchdog, will be acting as a watchdog while resolution of dispute, and the parties are been convenient to discuss among themselves and resolve the dispute. This is the very good crux of the mediation process. Faster outcome. There exists no set procedure for mediation and thus providing parties an access to a wide range of outcomes. The resolution achieved by the process of mediation sometimes aren't possible through arbitration or judicial procedures. And that is where I will discuss with some examples with relation to the faster outcome and how this outcome are helpful in the upcoming slide as well. I will, with the help of couple of examples, I will provide you with that. But here the faster outcome over here is like it is a speedier in nature, because the parties are party centric. Being it's a party centric process, it's up to the parties to resolve the dispute, and it can resolve most of the outcomes, because although the disagreement will be with respect to one object, but the other object is they can also even discuss during that time, and even whatever the scenario it may be, they may discuss and resolve the disputes or disagreements or their interest, whatever the interest they are aligned with, so they can even discuss that. In re expeditious trial case under section 138 of NI Act, wherein Supreme Court requested the High Court to identify the pending revision arising out of complaints filed under section 138 of the NI Act and refer them to mediation at the earliest. Even the Supreme Court, recognizing that the mediation procedure being speedy in nature, it requests the High Courts to identify the pending revisions and ask them to refer to the mediation to settle at the earliest. And support, wherein the mediators are trained enough to support the parties during the difficulty situation by means of removing the deadlock. In case if the parties are in the grave nature, wherein they are in a mood of fighting, under that circumstances, like, the mediator are trained enough to support such parties and removes the deadlocks and can take the mediation process further to resolve the disputes. In case there are certain deadlocks as well, like where in case both the parties are not agreeing to reach at an amicable settlement, under that circumstances, the mediator are trained enough to use the worst that we call it is an Vatna and Bhatna methodology to resolve the disputes. So even the mediator can use such techniques to resolve the dispute, to remove the deadlock and move further with the mediation process. So the mediators are trained enough. For the training program, the mediator has to undergo the 40 hours of mediation training program as prescribed by the Supreme Court manual and the Supreme Court as well. And with respect to that, like, there are various private organizations which are providing the mediation training programs, and to become a mediator with the private mediation centers, to become as an accredited mediator with a private mediation center, the mediator has to undergo the 40 hours, the mandated 40 hours mediation training programs to be accredited with the private mediation centers. With respect to accredit with the statutorily established mediation centers, the mediator is required to be adhere to the qualifications which are laid down under the specific acts or statutes. So preservation of relationship, another important factor that feature of the mediation is like mediation preserves the relationship. Like whether it may be business or family disputes, preservation of relations can be a key benefit of mediation, because mediation helps the participants focus on effectively communicating with each other as opposed to attacking each other. So mediation process is like it's an effective communication, and with the help of the mediator, that the role of being a facilitator of the mediator, he provides an environment of such effective communication between the parties, wherein he tries to avoid the oppositions, to avoid the attacks on both the parties each other. So he tried to avoid that. He create an environment of effective and efficient communication and to resolve the dispute, wherein in under that circumstances the relations are maintained with the mediation. Along with that, another additional feature or advantageous feature of a mediation is like refund of court fees. In case of Nutan Batra versus Bunyad Associates, even this is a case of 2018, and based on this case itself, other like section 89, section 89 and the rules laid down under this civil procedure code, the Consumer Protection Act of 2019 and the rules laid down under that. So these all provides, if a matter has been settled through mediation, the court fees which are being paid by the parties for that dispute will be refunded back to the parties themselves. So the court fees will be refunded, and the same was been held in Nutan Batra versus Ms. Bunyad Associates. So with relation to win-win situation, with relation to how the relations are being preserved, I would like to explain with one couple of examples laid here in two pictures. Like in one picture, like on the two sides there we have some grass which has been provided to fed the, I can say it's a horse, or you can take up with anything. So there is a two grass items to feed the horses, but the two horses, when they stretch each other on the different sides. So you can see in the example 2 wherein, so this is like in the example 1, like the picture 1, wherein the if both of the parties are like attacking or opposing each others, then they can't eat anything. If they try to settle, and if they both together, if they go on both the sides and eat something, it will be a win-win for both of them, and even the relations are being preserved. In the first scenario, there is another scenario, the example of a mediation. There is another example of a mediation wherein, so there are two friends, and both friends focuses on their interest, that is orange. Both of them wanted a orange, and they were opposing each other. Like, I want the orange, and the other also seeks that I wanted a orange. This is a famous example, and everyone knows about this example when we talk about mediation, and even everyone talks about this example when they talk about mediation. So in this case, what happens? Like, both of them wanted orange, but why they wanted the orange? What was the interest behind this? What was the interest behind this orange of both the parties? One of them wanted to make the juice, and the other wanted the rind of that orange to make a cake. So that is where how everyone wins in this situation is like, one will be getting the orange pulp to make a juice and a orange rind to make a cake. And that is where the mediation process, during a mediation process, both the parties themselves negotiate actual what is their interest, and based on the interest they resolve the dispute and creates a win-win situation for both the parties. And this is why the relations of the parties are also being maintained, and which is very much essential in this competitive world as well. So mediation settlement cannot be challenged if once the mediation is been drawn. If once the mediation has been settled through mediation, then it cannot be challenged before any court, and the same has been laid down in Abhinav Cooperative Group Housing Society Limited versus Uppal Engineering Company Private Limited, that the court held that if the sanctity of the mediation settlement and the courts did not allow the parties to backtrack from the terms and condition of the settlement on the ground that in case the same is allowed, it will negate the aims and objective of the mediation and defeat the whole process of mediation. What happened in this case is that the mediation is conducted in Delhi High Court, and the mediation and conciliation sector, it drawn an agreement, mediation settlement agreement, and the application was been filed in this section, in this case, before the Supreme Court to draw that the mediation which is conducted at Delhi High Court Mediation Center to declare it as void. And the court held that Mr. Deepak Uppal held that the Sanctity of the mediation settlement and the court did not allow the parties to backtrack from the terms and condition of the settlement on the grounds that in case the same is allowed, it will negate the aims and objective of the mediation and defeat the whole process of mediation. See, the mediation process is like being a voluntary, being a party centric, wherein the party themselves reach to an amicable settlement, draws the consent. With the consent of the parties, the mediator will draw an agreement wherein both the parties sign on the agreement and reach to the settlement. And based on that, the same thing was challenged. That contention of the party in this case was that the mediation was being arrived at the mediation center, and there was no withdraw, that there was no consent at all for that. When the parties themselves has resolved the dispute, when the mediator with the consent of the parties has drawn the agreement, when the parties have signed on the agreement with others witnesses as well, in such circumstances, do you think like there is no consent of the party? It can't happen, because the party themselves has resolved the dispute by means of entering into an agreement. Once the agreement has been resolved, that means it's a binding nature. And that is why the court held that, like, if at all we allow this mediation agreement to be void, then the very aim and objective of the mediation will defeat. And that is where it upheld it, that if a mediation settlement is happened, it cannot be challenged before any court of law. The same thing also held in case of Naveen Kumar versus Srimati Khalia Devi as well. Wherein, here in this case, the plea of ignorance as taken by the defendant number 1 is nothing but an afterthought in order to back out from the settlement arrived at before the learned mediator. It appears that she wants to wriggle out of the settlement agreement which has been entered into by her before the learned mediator for obvious reason. So, here, mediator is an independent person. He has categorically mentioned in his proceedings that the parties had voluntarily and of their own free will had arrived to an amicable settlement resolving their dispute. And the parties have voluntarily of their own free will arrived at this settlement agreement in the presence of mediator. So when he has written in the report and even in the statement settlement agreement that the parties have been voluntarily agreed the settlement, whatever the term it may be, when he has written, when the parties have signed on that, it means that the mediation is been settled out, or the mediation is been agreed by both the parties and with the consent of the parties. So that is why the mediation settlement cannot be challenged in any court of law. So need of Special Mediation Act. So when we look after the various features, so even although the Consumer Protection Act, we have various other legislations which recognize mediation, but still we feel that there is a requirement of Mediation Act, and the same was been discussed in case of M.R. Krishnamurthy versus New India Assurance Company Limited and others, wherein the 18 years advocate, a practicing advocate, was suffered with an accident and which his entire left leg was crushed, approached the court with a plea seeking reform in the motor vehicle accident claim system, that wherein this case was being heard by Dr. A.K. Sikri and S.A. Nazir, asked the government to consider the feasibility of enacting the Mediation Act to take care of the various aspects of mediation in general, because as we all know that the motor vehicle accident claims takes lot of time in settling the claim, in settling the motor vehicle accident claim, and that is where Honorable Judge A.K. Sikri and S.A. Nazir requested the government to enact the Indian Mediation Act, and accordingly the government of India came up with the mediation bill in the year of 2021, and the same bill is passed day before yesterday, recently by Rajya Sabha. So we'll hope we will see this Mediation Act soon in an official gazette. With this, I conclude this session. Thank you.